You know, we've probably all thought about it. Renting out our place for a little extra cash. Seems simple, right? But what happens when a totally modern side hustle smacks right into a set of rules from the 90s? Today, we're diving into a fascinating battle between a successful Airbnb host and her HOA, and it all comes down to rules that were written before most of us even had email.
So this really gets to the heart of the matter, and it's something that could affect tons of people. Can a homeowners association really use a rulebook from 3 decades ago to shut down a business like an Airbnb? Well, the answer isn't as clear-cut as you might think. It all boils down to how you read the words on the page.
Okay, so how does a simple rental listing blow up into a full-blown legal hearing? Well, our story kicks off way back in 1994. That's when the neighborhood rules were first drafted. Fast forward to 2006, and Jennifer Sullivan buys her townhome. Everything's fine until 2021, when she starts her Airbnb. And then, bam, by the summer of 2023, she's in front of a judge, fighting for her business.
All right, let's look at this from the homeowner's side first. As far as Jennifer Sullivan was concerned, she wasn't doing anything wrong. In fact, she was pretty confident that the HOA's own rules were on her side.
Her entire argument really came down to this one simple, powerful point. She'd read the documents, inside and out, and she said, nowhere in here does it say anything about a minimum lease period. To her, it was simple. If the rule wasn't explicitly written down, it didn't exist.
So let's get into the nitty-gritty. The key sentence says the rules shall not preclude, which is just a fancy way of saying prevent, rentals for a month or longer. Sullivan's logic was kind of brilliant. She argued, hey, if they went out of their way to specifically allow long-term rentals, but they didn't say a single word about short-term ones, well, that must mean short-term rentals are okay too. It's what lawyers call an argument from silence.
And look, she wasn't just winging it here. She came prepared. Her own lawyer agreed with her. And get this, even an early opinion from one of the HOA's lawyers seemed to say, yeah, this doesn't prevent short-term rentals. Plus, you got to remember, she was a model host, a superhost with a nearly perfect rating. And maybe the most important point of all, in her entire time renting, there had been 0 complaints from neighbors, not one.
Okay, that sounds like a pretty solid case for the homeowner, right? Well, not so fast. The HOA had a completely different way of looking at things, and their argument was all about the original spirit of the community. To make their point, the HOA brought in the original developer of the community, a guy named John Vale, and he put it in really personal terms. He basically said, look, people bought these homes expecting to have neighbors, not to live next to what's essentially a hotel with a revolving door of strangers. For him, this was about preserving the very character of the neighborhood. So the HOA focused on a totally different part of that exact same rule. The very first sentence says no gainful occupation, basically no business, can be run out of these homes, period. They argued that the part about month-to-month or longer rentals wasn't just allowing long-term rentals, it was the one and only exception to an otherwise complete ban on running a business.
And they backed this up with history. They said, hey, for 29 years, everybody in this community has understood this rule to mean there's a 30-day minimum. This wasn't some new idea they just came up with. This was the way things had always been. It was the community standard.
And to prove this wasn't just talk, they pointed to 2 other times this had happened before. In both cases, a homeowner started doing short-term rentals, the HOA sent them a notice, and the rentals stopped, just like that. This, they argued, showed a clear, consistent history of enforcing this 30-day rule.
So the HOA's case was really built on these 4 pillars, right? You have the original developer's intent, the argument about protecting the community's vibe, their own legal opinion saying they had a fairly strong argument, and proof that they'd even put reminders about the policy in community newsletters.
So there you have it. 2 sides looking at the very same sentence in the rulebook and coming to completely opposite conclusions. One is all about the literal text, the other is all about history and intent. How on earth does a judge even begin to unravel this?
Let's just take a second here. After hearing both arguments, who do you think has the stronger case? Is it the homeowner who's saying, hey, the rules don't specifically say I can't do this, or is it the HOA with nearly 3 decades of history backing them up?
And the judge's decision came down on the side of the HOA. Jennifer Sullivan's petition was denied. The violation was upheld. In short, her Airbnb business was not allowed.
So why? Well, the whole thing hinged on those 2 words, gainful occupation. The judge's logic was that since Sullivan had a business license and a tax ID for her Airbnb, it was, without a doubt, a business. And since the rules clearly banned any gainful occupation, the only way around that ban was the one exception they provided: rentals of a month or longer.
So, okay, a single dispute in Arizona gets settled. Case closed. But the ripples from this decision go way beyond just one neighborhood. This really speaks to anyone living under HOA rules while also trying to make a living in the modern gig economy.
So what are the big lessons here for the rest of us? Well, first, history can be a really big deal. How a rule has been interpreted for years can actually be more powerful than the words themselves. Second, that old argument, well, it doesn't say I can't, isn't a slam dunk legal defense. And finally, this is a huge reminder that a rulebook from 1994 can absolutely shut down your very 21st century business.
And all of this leaves us with one last big question to think about. In a world where technology is changing faster than we can keep up, whose job is it to adapt? Should we reinterpret old rules to fit these new realities we're living in? Or should new businesses have to find a way to fit into old, pre-existing frameworks? That's the question at the very heart of so many of these fights, and there's no easy answer in sight.